Hello, everyone, and thank you for attending today's webinar. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget. We'll try to answer these during the webcast, but if a fuller answer is needed or we run out of time, it will be answered later via email. If you experience any technical problems during the webinar, those can also be reported through the Q&A widget. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the help widget. This webinar is CLE accredited in 1 hour of general credit in California, 1 hour of general credit in Illinois, 1.2 hours of general credit in Missouri, 1 hour of professional practice credit in New York for experienced and transitional attorneys, and 1 hour of general credit in Texas. This program has also been submitted for SHRM and HRCI credit. CLE credit is awarded based on full attendance. To verify engagement, secret words will appear in multiple choice polls during the webinar. Please respond to these polls to receive full credit. We value your opinions and appreciate your participation in the course. My name is Fatma Khan, and I'm a partner and immigration practice group leader at Thompson Coburn. I'm joined today by 2 other immigration attorneys on my team who are counsel at the firm, Martha Mendes Fisher and Molly Hennessy. And we thank you for joining us today. As you've all seen and heard, immigration has certainly been in the headlines every day, especially under this current administration. It seems there are new changes and developments and policies and memos and proclamations very frequently issued. It seems to be a roller coaster most days, and we're just sort of on edge waiting for the next unpredictable change. So that being said, before we jump into the H-1B lottery, we wanted to do justice by covering a few of the other pertinent developments that have happened in the past year affecting immigration. I wanted to just highlight some of them here, and we're going to go into greater detail on each of these topics. So we'll start off by covering some of the travel bans and related adjudication holds and policies, the uptick in visa revocations, enhanced vetting measures, increased enforcement efforts, and the termination of certain humanitarian benefits and the TPS programs, as well as an uptick in requests for evidence and denials on petition filings, overall longer processing times on our filings, as well as covering the numerous changes with the H-1B lottery program starting this year. So let's get into a bit more detail on each of these. So to begin, I'm going to turn it over to Molly to cover the travel bans.
Thanks, Fatma. So I imagine many of you recall that there were travel bans during President Trump's previous term. So it was expected by most that there would be something similar in his present term. The initial ban was announced via a presidential proclamation on June 4th, 2025, with an effective date of June 9th. Now, this is a ban only on entry. So under the 4 corners of the proclamation, it does not impact adjudication of applications or petitions filed with U.S. Citizenship and Immigration Services. Nor does it impact foreign nationals already within the United States, which I imagine involves many of your foreign national workers. It's really more focused on the visa issuance process handled by the State Department abroad. Regardless, for those potential employees abroad and without a valid visa on the effective date, the ban does lay out 2 different types of suspensions on entry. There's first a complete suspension on entry, and then a partial suspension on entry, so for only certain types of visas, and I'll talk about each one. So for the complete suspension or the complete ban, that's for nationals of 12 countries, and this means that they cannot obtain visas and therefore come to the U.S. on both a temporary basis as a non-immigrant or on a permanent basis as a green card holder. There were 12 countries covered by the complete suspension in the initial travel ban. We have links at the end of our presentation to the actual presidential proclamations where you can view the complete list. But those 12 countries included Afghanistan, Haiti, Iran, and Libya. Now, as for the partial suspension in the initial ban, that covered another 7 countries. Like I said, it wasn't a complete ban or a complete suspension on entry, but it did prohibit issuance of certain non-immigrant visas namely visitor and student visas, and then also immigrant visas for the 7 identified countries. And again, you can look at the full list in the links at the end, but that included Cuba and Venezuela as examples. There are several exclusions and exceptions to the travel ban. As for the exclusions, it doesn't apply, the ban does not apply to anyone who is already a lawful permanent resident or a green card holder. It also doesn't apply to anybody who's a dual national, so that means somebody that holds nationality from 2 different countries, as long as they are traveling on the passport of the country that is not covered by the ban. So in that circumstance, they would not be subject to the ban. Immigrants applying as immediate relative family members were also excluded under the initial ban. So folks that were married to U.S. citizens, the unmarried children of U.S. citizens, or people who are parents of adult U.S. citizens seeking to come to the U.S. as an immediate relative immigrant were excluded from the initial ban. There were also additional exclusions for example, people who were coming to the U.S. based on adoption by somebody in the U.S., or special visas for U.S. government employees, or people from Afghanistan. In addition to those exclusions, there's also 2 exceptions to the travel ban. The first one is for individuals who the Department of Justice determines are going to advance a critical national interest involving the work of the Department of Justice. So that's primarily going to be people who are coming to the U.S. to serve as a witness in criminal proceedings. The second exception that I think is more broadly discussed or known is an exception. It's case by case, determined by the Secretary of State in consultation with the Secretary of Homeland Security for individuals that they determine would serve the national interest. So this national interest exception is pretty rarely, the State Department said that it's going to very rarely grant these. So it's not something that's going to occur a lot. And the process is that the person would first have to be found eligible for whatever visa they're seeking, and then they would apply at the consulate abroad for the national interest exception. It's not like a separate application that's filed in advance. It's just part of the consular process. So like I said, the Department of State said that these would be granted in very rare circumstances, and they specifically said that they're not going to be granted for routine business travel, employment, visiting family members, or to come study in the U.S. Okay, so that was the initial one that came down in summer of last year. And then in December, an updated travel ban was issued by presidential proclamation, this one with an effective date of January 1st, 2026. The timing of this update was a bit tricky, as many foreign nationals living in the U.S. travel abroad over the holidays, and if their visa had expired and they were applying or planning to apply for a new one, the ban could ultimately apply to them. So on this one, again, there was that break between a complete suspension and then a partial suspension on entry. So there were 7 new countries added to the complete suspension for a total of 19 countries. And then in addition to that, individuals traveling on Palestinian Authority issued or endorsed travel documents were also covered by that full ban. 2 of the countries covered in the updated travel ban as a complete suspension were countries that were initially included as partially suspended under the first ban. So that's Laos and Sierra Leone. So they were more restrictions were placed on them as part of this second updated ban. And then there were 5 other new ones added. For the partial suspension, the 5 original countries stayed on the list other than the 2 that moved to the full ban. But one was revised for Turkmenistan. They lifted the ban on non-immigrant visitors and student visas, but kept the ban on immigrant visas, so permanent green cards. And then 15 new countries were added. And you can reference those in the links we include at the end. But some of the new ones include Dominica, Nigeria, Senegal, and Zimbabwe. This revised travel ban did include similar exclusions, but they were a bit narrower. Green card holders and dual nationals are still excluded, but they removed the exception for immediate relatives of U.S. citizens. They also removed the exception for special immigrant visas for certain Afghans. As I mentioned, this is just a ban on entry, essentially visa issuance. That being said, USCIS has also taken similar steps, which Martha is going to go over in the next slide.
Molly. The United States Citizenship and Immigration Services has issued a series of policy memoranda that effectively place a hold on processing or completing decisions on many immigration benefit applications. The administration cites the need for enhanced security vetting and national safety reviews as the basis for the adjudication hold. The USCIS issued the first memorandum on December 2nd, 2025, holding adjudication of all pending applications for benefits, including I-485 applications for adjustment of status, I-90 applications to replace green cards, and 470 applications to preserve residence for naturalization purposes, I-751 applications to remove conditions on residence, and I-131 applications for travel documents or advanced parole documents for foreign nationals of the 19 countries included in the initial travel ban. The memo also orders a comprehensive re-review of previous approvals of immigration benefit applications for foreign nationals of the same 19 countries who entered the U.S. on or after January 20, 2021, including a potential re-interview if deemed necessary. Thus, foreign nationals of the designated countries who have already been granted green cards are having those applications re-reviewed and may be called for re-interviews. The memorandum also placed a hold on all I-489 applications for political asylum and withholding of removal, regardless of the foreign national's country or nationality, pending a comprehensive review. On January 1st, 2026, the USCIS issued a second memorandum expanding the adjudication hold of pending applications to include foreign nationals of all 39 countries and the Palestinian Authority covered in the new travel ban, as well as expanding the re-review of previous approvals to benefit requests approved on or after January 20, 2021 for foreign nationals of all 39 countries and the Palestinian Authority. The adjudication hold applies if a foreign national is born or is a citizen of one of those countries listed in the memos and does not exclude dual nationals. The nationals of the countries subject to the adjudicated hold and comprehensive review include Afghanistan, Angola, Burkina Faso, Cuba, Haiti, Iran, Nigeria, Sudan, Venezuela, among others. A link of a complete list of the countries included in the adjudication hold is included in our list of resources. Now, let's hand it off to Fatima, who will discuss the consular visa process and other visa issues.
Thanks, Martha. So yeah, there's been a lot of developments in the consular space, particularly with respect to visa revocations, which we've seen happen with increased frequency over this past year. It started back in early April of 2025 related to F1 students, where ICE began unilaterally terminating F1 student status holders' CVIS records without any prior notification to universities or students. That action was followed quickly by emails being sent from the respective US consulates regarding F1 visa revocations. And this happened very rapidly nationwide in the thousands. Upwards of 5,000 to 7,000 foreign national students on F1 status had their CVIS records terminated. And often it was just based on minor infractions. In some cases, no interaction whatsoever with law enforcement, or in certain situations, there may have been an arrest, but charges were dropped. There was no conviction record. Thankfully, there was a flood of litigation and emergency orders blocking the termination. By late April, ICE began backpedaling and eventually restoring the CVIS records, but unfortunately it came too late for many of the F1 students who actually departed the US out of fear of being put in deportation proceedings. Then we saw similar activity with respect to H-1B status holders, where visa revocation emails were being sent from U.S. consulates abroad. And these were also predicated on similar circumstances where there was maybe very minor interaction with law enforcement, like a parking violation. And in all of these instances, it seemed to be based on computer AI generated searches without any substantive review whatsoever. And you can imagine the detrimental consequences of such actions with respect to visa revocations. There's also been additional developments in the whole consular processing space. And, notably over the past few months, with respect to presenting visa applications for stamping, the Department of State eliminated the option of third country visa processing with very few exceptions. Also, many of our clients had become accustomed to interview waivers. That too was eliminated, and now in-person interviews are required for most all non-immigrant visa applications, including for minors and for seniors. There's also been a significant uptick in vetting procedures at the consulates, often resulting in significant administrative processing delays, particularly with respect to the review of social media presence of all visa applicants. And, there's also been a pause on immigrant visa issuance for nationals of those 75 high-risk countries that Molly was discussing earlier. All of this is to say that we've been inundated with questions with respect to international travel and visa stamping, and seeing everything that has happened over the past few months, often with very little notice. Our general position has been to really encourage visa holders and their employers to very carefully consider any decision with respect to international travel, especially where visa stamping is needed, particularly for F and H-1B and H-4 visa holders. That's just to highlight some of the developments in this space. We want to also focus on some of the other notable developments, including an uptick in enforcement efforts. And for that, I'll turn it over to Molly.
Thanks, Fatma. So, in addition to everything else going on, there has been an increase in enforcement efforts in a lot of different ways. The first thing I want to talk about is something that's new. It's called the Project Firewall from the Department of Labor. And this is a new enforcement initiative that was announced last fall with the idea to maximize compliance with the H-1B program and prevent adverse effects on similarly situated U.S. workers. The Wage and Hour Division actually released a flyer that kind of breaks down the goals and what this project is about. And within that flyer, they really focus on highlighting that employers must not undercut U.S. workers' wages or the benefits offered to U.S. workers by paying H-1B workers less or offering them fewer benefits. So that's kind of a key part of this initiative. There are a couple of unique facets of Project Firewall. First, the messaging from the Department of Labor has indicated that they will be pursuing Secretary's certified investigations. They've had the authority to do this since 2003, but have not really used this tool previously, and that's why this is notable. Prior DOL investigations into LCAs, into the labor condition applications, were usually complaint-driven. So they came from like an aggrieved employee who felt like the LCA hadn't been complied with the attestations tied to that. So we expect that we may see more investigations on LCAs, and they could come from a variety of sources. So they could come from referrals from other agencies, someone within the company, like a whistleblower who's perhaps not an H-1B worker, but reports concerns or complaints. And it could also be somebody completely independent from the employer, so some outside entity or individual. Another unique aspect of the project is the breadth of collaboration among government agencies. The announcements indicate that the Department of Labor plans to collaborate Obviously with DHS and USCIS, which makes sense given USCIS was involved in adjudicating H-1B petitions. But they also mentioned collaboration with the Department of Justice's Civil Rights Division and the EEOC. So it's pretty clear that they're looking at evidence of discrimination against U.S. workers. Given that, we think it's important for employers to be mindful of the attestations that you're making on the labor condition applications, which include attesting that you are going to offer non-immigrant workers benefits that are comparable or on the same basis as those offered to U.S. workers. Okay, so in addition to the Department of Labor's new Project Firewall, there's also increased enforcement efforts of what you may be more familiar with. So that's the USCIS site visits, I-9 audits, and I'm going to touch on those really quickly here. So the USCIS site visits, I think people are more familiar with these, but we are seeing an anticipated continued uptick in these compliance visits. And these generally they can relate to non-immigrant or immigrant employment-based statuses. So typically L1s or H-1Bs, Es perhaps, but also it could be for I-140s, so EB-1Cs or other filings. And really the goal is just to make sure that what is being represented in petitions filed with USCIS is accurate. So confirming that the job duties are correct, that the person's at the work site that they're supposed to be at, those types of issues are what they're going to be looking at. In order to plan for these kinds of site visits, you want to make sure you have an identified representative who's able to handle the inquiries and knows what they're supposed to do. And then you also want to make sure that all of your files are accurate and correct and up to date. So your public access file, which is required as part of the H-1B process, making sure that's easily accessible and it has the information in it that the regulations require. If a site visit does occur, the first thing is verifying the credentials of the person who's presenting themselves and asking for information, and then escorting them and providing them what they need. One thing to keep in mind is just making sure that you provide only the information requested. I think it's human nature to want to be helpful and compliant, but I think it's important in this context to be careful and to provide strictly the information requested or needed and not more than that. And of course, you always want to loop in your immigration counsel either during the process or after to update them about what happened. Okay, I-9 audits. These are conducted by ICE, not USCIS, so a different subcomponent of the Department of Homeland Security, and have gone on for years, but we are seeing them more frequently now. In order to prepare for these in advance, it's helpful to double check your I-9 processes to make sure that you're completing the process timely and accurately. You want to make sure you have a workable system or process to monitor which cases require re-verification so that you're timely doing those and making sure you're documenting them as needed. Employers can also consider conducting internal audits to check their I-9 compliance, but I think it's important to be mindful of the anti-discrimination provisions that relate to I-9s as well. So you can't just strictly do an internal audit of foreign national employees or conduct an internal audit in a way that discriminates based on national origin or immigration status. So just being mindful of that and thinking about how to conduct the audit in a way that keeps in mind those anti-discrimination provisions. I would also encourage employers to get comfortable with the I-9 handbook. I know that sounds super nerdy, but it's a really great resource, particularly in these the current times where things are kind of constantly in flux and changing pretty regularly. Bookmarking it as a favorite on your Chrome or whatever you use so that you can easily access it. And I-9 Central is helpful as well. Both USCIS run websites that provide great guidance for employers. Like I said, there has been kind of a lot of movement and changes with regards to employment authorization, particularly with TPS and automatic extensions of employment authorization documents, which Martha's going to discuss here in a minute. But the I-9 handbook is a great resource because it provides up-to-date information on those issues. And something else to keep in mind is that and I said this a couple of times, but things have been changing with little notice because of ongoing litigation relating to some of these matters. So just always double checking to make sure you have the most accurate and current information is helpful, even if it's something that maybe you checked just a few weeks ago. If you do receive a notice of inspection of an I-9 audit, that's when you're going to want to reach out to your counsel immediately, loop them in so that they can assist and walk through the process together. And then finally, we just wanted to mention that we anticipate that there will be an increase in investigations on F1 STEM extensions. Even though this is a USCIS process, or USCIS is the one that processes the employment authorization documents tied to STEM OPT extensions, the investigations will be conducted by ICE since they're the ones that administer the F1 program through CVIS. And as you may all know or recall, to get the OPT, the STEM OPT extension, the employer has to complete a training plan. And so we anticipate that ICE may conduct site visits to review the training plans, ensure the employee is complying with the training plans, kind of similar to what the USCIS site visits do in the H-1B/L and other non-immigrant worker contexts. So they're really just making sure that the training plan is accessible, that you have it, what you want to be thinking about is making sure the training plan is accessible and that you have a designated representative who can answer questions. Okay, so now I'm going to pass it back to Martha to talk a little bit about those recent changes in certain humanitarian benefits like TPS that I mentioned earlier.
Thank you, Molly. As Molly mentioned, that we have also seen developments in programs, humanitarian programs. The USCIS has eliminated or suspended several humanitarian programs that once offered legal entry and work authorization to foreign nationals, as well as other benefits, including parole programs such as the Afghan parole program, H-1B parole program, for Venezuelans, Cubans, Haitians, and Nicaraguans, the Family Reunification Parole Program for citizens of Colombia, Cuba, Ecuador, El Salvador, Guatemala, Haiti, and Honduras, and their immediate family members. Also, there has been a termination of temporary protected status, more commonly known as TPS, and associated employment authorization permits for foreign nationals from Afghanistan, Burma, Cameroon, Ethiopia, Haiti, Honduras, Nepal, Nicaragua, Somalia, South Sudan, and Venezuela. However, there is ongoing litigation lawsuits involving the family reunification parole programs and some of the TPS programs, so we can expect more changes in the near future regarding these programs. In addition, the USCIS eliminated automatic extensions of employment authorization documents filed on or after October 30, 2025. Previously, if an applicant had timely filed an application for extension of work authorization, he or she was granted an automatic extension of work authorization from 180 days to 540 days, depending on the specific category, while the application remained pending. Unfortunately, that automatic extension is no longer available. However, automatic extensions already granted for renewals filed before October 30, 2025 remain valid. Thus, although challenging, it is important to stay apprised of these changes for I-9 compliance purposes, as Molly mentioned before. Now, it is time for our first secret word. The first secret word is medal, like an Olympic gold medal. Please select medal from the options below. Again, the first secret word of the day is medal. Once more, our first secret word of the day is medal. Now I turn it over to Fatima to provide us with an overview of the H-1B process.
Thanks, Martha. So now that we've covered several of the broader immigration developments over the past year, we wanted to shift gears and focus on the upcoming H-1B lottery and changes with respect to that program. So we'll review the eligibility requirements and discuss some of the employer obligations related to the program. As a reminder, there are still 85,000 new CAP subject H-1Bs available annually, with 20,000 of those set aside for the master's CAP for individuals who have attained a U.S. master's or higher degree. Also, as a reminder, on the slide, we wanted to provide the regulatory definition of an H-1B specialty occupation. Notably, it's defined as those occupations that require a theoretical and practical application of a body of highly specialized knowledge and the attainment of a baccalaureate or higher degree. So some of the more common types of occupations that qualify as H-1B include software developers and other IT professionals, engineers, architects, physicians, scientists, other healthcare professionals, certain business occupations in finance, supply chain, logistics, also accountants, auditors, as well as teachers and professors. By no means is that an exhaustive list, but we just wanted to highlight some of the more common ones that are considered to be specialty occupations. And now we'll go over some of the broader parameters with respect to H-1Bs. I'll turn it over to Molly.
Thanks. So just a quick overview of the H-1B status before we dive into some of the more recent changes. There is a time limitation on H-1B status, so the foreign national cannot remain on an H-1B indefinitely. It's generally available for 6 years, and that's broken up into 2 3-year periods of time. The 6-year time limit is not per employer, so it doesn't restart if the foreign national worker changes employer. So it's just a total amount of 6 years. It doesn't reset. There is an option to extend beyond the 6 years for certain individuals who are pursuing permanent resident status, but they do have to meet certain benchmarks by certain times to be able to get that extension beyond 6 years. So it's important to discuss with your immigration counsel at least a couple of years before the employee hits that six years to make sure that the employer is doing what they need to be doing to get that extension beyond 6 years if that's what's desired. There is a dependent status available for spouses and minor children of H-1Bs, and that's the H-4 visa status. Additionally, H-1Bs must have a valid visa to both initially enter the U.S. and then if they travel abroad to re-enter if their prior H-1B visa has expired. And this is important to keep in mind. I know we've already touched on this a couple times, but there have been recent delays in visas processing, so getting the visa stamp in the passport. So knowing whether a foreign national employee has a valid visa to be able to re-enter before they travel internationally is really important to keep in mind. Finally, the process does involve several federal agencies. Obviously, it involves the Department of Labor, which handles the labor condition application. That has to be filed and certified before the H-1B petition can be filed with U.S. Citizenship and Immigration Services, who then adjudicates that petition. The State Department is involved in the sense that they adjudicate and issue the H-1B visa in the person's passport, which allows the worker abroad to then enter the U.S. in H-1B status. And then finally, U.S. Customs and Border Protection is also involved as they're at the port of entry. So the land border or the airport where the foreign national worker comes into the U.S. and they ultimately decide whether they'll be admitted in H-1B status or not. So there's a lot of moving parts and agencies involved in the H-1B process, but that's just a quick overview. Okay, I'm also going to just run through the beneficiaries' eligibility requirements really quickly. They must hold at a minimum a U.S. bachelor's degree in the field of study required for the specialty occupation. And that degree must be from an accredited college or university. And they must have completed the degree at the time of filing. So you can't file a petition for somebody in April with an October 1st start date if they won't complete the degree until May. They have to have completed the required degree by the time the petition is filed. A foreign equivalent of a U.S. bachelor's degree is also sufficient, but that will require a credential evaluation to document that it is equivalent to the U.S. Degree. And it's important to be mindful that there are some 3-year bachelor's degree in other countries, like Australia, that may not be comparable to a U.S. bachelor's degree. And then finally, you can also do a combination of education, training, and work experience, and show that that is equivalent to a U.S. bachelor's degree. That also requires an equivalency evaluation and so includes an additional cost, but it is an option. And then finally, if a state license or certification is required for the job at issue, then that's also going to need, proof of that is also going to need to be provided at the time of filing to show that the foreign national holds that required license or certification. Okay, so that was just a quick summary of the requirements for the employee, and Martha's going to talk a little bit about the employer obligations.
Thank you, Molly. Please note that the H-1B status is employer position and work specific. What does this mean? That the beneficiary is only authorized to work for the employer who submitted the H-1B application to the USCIS on his behalf, and only in the job position and work site included in the original H-1B petition. Before filing an H-1B petition, the employer must file and obtain certification of a labor condition application, or what we call LCA, from the U.S. Department of Labor. The LCA must list each work site location where the H-1B will work. The LCA must be posted either by physical or electronic notice at the work site and be included in the public attestation file. H-1Bs have strict wage rules enforced by the U.S. Department of Labor, and the employer must pay the foreign national the higher of the prevailing wage for the occupation in the geographic area of intended employment, or the actual wage, which means what the employer pays similarly situated workers. Wages are determined by the U.S. Department of Labor based on the position requirements, the degree and years of experience, the position duties and responsibility, whether the position is an entry-level position, mid-level, or managerial, and where the work is physically performed, the specific geographic locations of the work. Any material change requires a careful analysis of possible need for filing an amendment H-1B petition with the USCIS prior to the change going into effect, such promotions or role change, changing full-time to part-time status, or worksite location change, including going from hybrid and working from home changes. There are some short-term placement rules that allow limited temporary placement of an H-1B worker at new sites, generally between 30 and 60 days, but strict wage and reimbursement requirements apply. Now, the employers are required to keep certain records, including a public access file, which must include a certified LCA, wage rate explanation, prevailing wage source, posting notices, and a summary of benefits offered to U.S. workers. To properly end H-1B employment, the employer must notify USCIS by filing a request to withdraw the H-1B petition and offer to pay reasonable cost of return transportation to the employee's last foreign residence and document the termination. Until proper termination occurs with following those previous 3 steps, the wage liability for the employer continues. Now, let's talk about the lottery and give you a historic perspective about it. Beginning with fiscal year 2021 CAP season, the USCIS implemented an electronic pre-registration system. before the implementation of the electronic pre-registration system, employers were required to file complete H-1B petitions, including filing fees and supporting documentation upfront with the USCIS during the first week of April. Everybody rushed to file their H-1B petitions by April 1st. If the petition was not selected, then the USCIS will return the entire package by mail. Thus, employers absorb legal preparation costs for the unselected H-1B petitions. The demand for CAP-subject H-1B visas has always been high, often exceeding the annual supply. During the registration period for fiscal year 2026, as you will see in the chart, we saw a significant decrease, however, in the total number of registrations submitted and eligible beneficiaries compared to fiscal year 2025, including a decrease in the number of registrations submitted on behalf of beneficiaries for multiple registration. However, even when that demand was decreased, it also exceeded the annual supply. Now, I will turn it over to Fatima to address the new weighted lottery rule.
Thanks, Martha. So now that we've covered some of the general H-1B guidelines and important compliance requirements, let's get into the changes that are new this year. So just recently, there was a final rule published on December 29th, which goes into effect on February 27th, so affecting this upcoming lottery cycle. There are going to be changes with respect to the entries into the lottery system. So through this rule, the government is implementing a weighted selection process that generally favors the allocation of H-1B visas to higher skilled and higher paid foreign nationals. And this affects both the regular and master's cap. So essentially what this means is based on the wage that's offered in correlation with the occupational classification aligned with the job description, there can be additional entries or tickets into the lottery for a given foreign national. So every occupation has, in association with its geographical location, has 4 wage levels. And we have to carefully assess the offered salary to see which of the wage levels it most closely aligns with. An alignment with wage level 1 means 1 entry into the lottery. An alignment with wage level 2 means 2 entries into the lottery. An alignment with wage level 3 means 3 entries, and an alignment with wage level 4 means up to 4 entries into the lottery. And that's the weighted system now. So it's going to be based on the wages offered, not the wage level that's selected later on at an LCA preparation stage. So that's an important distinction. Also, with this new system, it encompasses what's known as a lowest wins rule, meaning if there's multiple registrations submitted by multiple employers for the same foreign national, the lowest wage aligned with the appropriate wage level is the one that will be used for that beneficiary among all of the different employer submissions. Also, if a foreign national is going to be working and placed at multiple worksite locations, the employer has to use the lowest wage leveling for purposes of registration. And this is designed to not game the system. So let's take a closer look now at the distinction with the analysis at registration stage versus LCA wages. So again, just to reiterate, at the registration stage, the leveling is based purely on the offered wage for the position in the respective geographical location. It's a simple comparison of the base salary with the DOL wage levels for the applicable metropolitan statistical area. This is assessed independent of the sophistication of the job, meaning we're not looking at the education or experience requirements when doing the pure wage analysis for registration purposes. Now, if an individual is selected at the lottery stage, the LCA analysis is distinct. And an LCA is a required component of an H-1B submission. Now here, the rules are not changed at all with respect to the LCA analysis. It's a complete, distinct procedure for identifying the appropriate wage level based on the sophistication of the job, meaning we take a look at the education that's required, the experience that's required, any special skills that's required, the job zone for the applicable occupational classification, and the educational coding associated with that occupation. This is irrespective of the salary offered. However, the salary that's offered has to also meet the prevailing wage. So we do have to take a careful look at the registration stage to make sure that the wage that's offered is also going to work for us at the LCA preparation stage. We can't have a different wage offered at registration than what's going to be included at the LCA stage. All of this to say that there's a lot more analysis that's done up front this time around with the lottery process than we've seen in prior years. So again, the important takeaway is that the registration wage level and the LCA wage level can be different as a result of the distinct analysis involved. Now we'll turn it over to Molly to get into some of the practical implications.
Thanks, Fatima. Okay, so what does all this mean from a practical standpoint? Since this is the first year, it sort of remains to be seen how everything's going to shake out. But we anticipate that more senior roles and those with higher wages will have a better chance of being selected in the lottery. It's also possible that less employers will enter their foreign national employees in the lottery this year. So that could also impact the chance of selection in the lottery. Regardless of the numbers, the biggest change with this new weighted lottery system, like Fatima mentioned, is that it requires more advanced planning and close coordination with your immigration counsel than what's been done in the last few years. I imagine some of you may remember before they had the electronic registry, a complete H-1B petition had to be filed, and I think Martha touched on this earlier. So for that, there was like a full wage analysis, the LCA had to be filed and certified, everything had to be completed and ready to file the petition so that it could be entered in the lottery. Then in 2020, when we switched to the electronic registration system, it didn't require as much advanced planning because the full and complete petition was not required, just the registration. So what we have now is kind of in between those two. While a fully completed H-1B petition is not necessary, the registration now does have to include the appropriate SOC code, the work site, and then the offered wage of the employee. So we do have to go through that analysis of the position and the job duties to determine the appropriate code, work site, etc., as part of the registration. It is really important to ensure prevailing wage compliance with regard to this whole process, and that ties back to my prior discussion about Project Firewall, the DOL enforcement efforts with regard to the H-1B program. There's going to be closer scrutinies, or we anticipate there will be closer scrutiny of LCAs to ensure compliance. And USCIS is looking for instances of employers trying to game the system, get an unfair advantage, or harm U.S. workers. We do understand that there are certain industries where it may be difficult to identify future work sites or anticipate future changes, particularly when you're filing a registration in March for a position that won't begin until October. But you can keep in mind that you can file the registration for a future position. So essentially what you anticipate the worker will be doing in October, not what they're doing now. So that is an option. Also, if there is a change in work site or some other change between the registration and the filing, that's not necessarily going to make it so that the person cannot get the H-1B petition, but it is something that's going to need to be documented and for business reasons. So why did this change? What are the business justifications for it? And what documentation is there to back that up? Any changes are going to be heavily scrutinized. So hopefully they're few and far between. USCIS really is looking for situations where the employer is trying to game the system. So that's something that you want to be aware of, and that advanced planning and close collaboration with your immigration counsel is really, really important. Before I kick it back to Martha to discuss some of the other new regulatory changes with regard to this new rule, I did also want to just quickly mention that USCIS has proposed revisions to the I-129 form that that will require disclosure of the education, experience, and skills required for the position. So that kind of ties into all of this in terms of having, identifying those details early in the process. That change, those revisions to the form have not actually gone through yet, so they're not final, but it is something that we think is coming down the line. So just to be aware of it. All right, I'll transfer back over to Martha.
Thank you, Molly. There's new language in the weighted lottery rule that have been included to establish that a petition will be denied if it is determined that the statements on the petition, the H-1B registration, or the application for a temporary labor certification or labor condition application were inaccurate, fraudulent, or misrepresented a material fact, including if the certifications on the registration are determined to be false. An H-1B cap subject petition will also be denied if it is not based on a valid registration submitted by the petitioner or a successor in interest for the beneficiary name or identified in the petition. Similarly, the USCIS may deny a subsequent new or amended petition filed by the petitioner or a related entity on behalf of the same beneficiary if USCIS determines that the filing of the new or amended petition is part of the petitioner's attempt to unfairly increase the change of selection during the registration or petition selection process. Thus, it is very important to screen for both present and potential future issues and to plan in advance prior to the H-1B registration, as any attempts to materially change the terms of employment in a subsequent petition, particularly one that results in a lower prevailing wage, will be heavily scrutinized if fraud is found. It could well result into deeper compliance and enforcement actions or spill over into other filings made by the same employer. Now it's time for our second word, secret word, and it is goal. Please select goal from the options below. Again, today's secret word is goal. Please select goal from the options below. Now, let's talk about the H-1B registration process and timing for registration submissions. The electronic registration began in 2020, by which employers are required to register foreign workers in the H-1B lottery before submitting a full H-1B application packet with the USCIS. The new organizational accounts were implemented last year. Prospective H-1B cap subject petitioners and legal representatives are required to create their own USCIS online organizational accounts to register each beneficiary electronically for the selection process. Then they link the accounts via online invitations. The new account setup is currently live, so first-time registrants can create an organizational account at any time now. Please note that the H-1B registration system will not be available until an organizational account has been created. Each account is also tied to a unique email address. If you are an H-1B petitioning employer who does not have a USCIS online account, you will need to create an organizational account. One important thing to consider before creating the organizational account is what email is going to be used for H-1B registrations. HR and company representatives must decide who will be in charge of the organizational account and what email address to use. Ideally, you will want to designate a generic email that several individuals have access to for monitoring H-1B registrations, rather than individuals' personal email address. If a personal company email is used and the individual leaves the company and that email is disabled, then all registrations in that account will not be able to be accessed. The H-1B registration process is a beneficiary-centric process, meaning each beneficiary can only be entered once per employer. And the beneficiary's identified information is tied to their valid passport and travel documents details. The current H-1B registration fee per applicant is $215. Recently, the USCIS announced that the initial H-1B registration period for fiscal year 2027 H-1B CAP will open at noon Eastern Time on March 4th and run through noon Eastern Time on March 19, 2026. Some practical steps that employers may take now to prepare for the upcoming H-1B registration are first, to identify potential applicants for the H-1B registration, such as recent student graduates in F1 optional practical training or STEM OPT employment authorization, F1 students with curricular practical training work authorization, individuals with H4 or L2 work authorization, employees holding trade, NAFTA, USMCA, TN status, or E status who may later pursue permanent residence, employees present in the U.S. in other non-immigrant status nearing maximum time limits in the specific visa classifications such L-1B visa holders, and individuals currently working for CAP exempt organizations who have never been counted against the H-1B CAP. After identifying potential applicants, employers should begin compiling job descriptions, salaries, and work size for each individual. Now, let's talk what happens after the registrations have been submitted. Then they will be selected, and the selection will take place after the initial registration period closes, when USCIS will run a computer-generated lottery. As Molly mentioned before, the new lottery registration system favors higher skill, higher paid positions. USCIS will first select from higher wage levels, significantly reducing the probability for level 1 wages by an estimated 48%, while increasing chances for levels 3 and wage level 4 levels. The initial selection process is expected to be completed by March 31st. If selected, USCIS will post notice in the online portal, and employers will have 90 days to submit completed H-1B petitions from April to June. Now I'll turn it over to Fatima to talk about the new $100,000 H-1B fee.
Thanks, Martha. So now that we've covered the new weighted lottery system and preparing for the lottery process, we wanted to address the development over the past few months with respect to this $100,000 fee. This came about by a presidential proclamation in September of 2025 and went into effect very quickly, 2 days after it was announced. So as far as who is subject to the fee, so let's focus on that. This includes petitions that were filed after that effective date of September 21, 2025 for individuals who are outside the U.S. who do not have a valid H-1B visa. It also includes H-1B petitions filed after the effective date seeking consular notification for activation of the visa, as well as petitions that are filed after the effective date seeking an amendment or change or extension in the U.S. where the USCIS denies the amendment, change, or extension of status. That too can trigger the fee. Now, as far as who is not subject to the fee, this includes petitions that are filed before that effective date of September 25. It also includes petitions filed after the effective date, but seeking a change of status or amendment or extension of status stateside, where a new I-94 will be generated on the I-797 approval notice. It also, those not subject to the fee include beneficiaries of an approved H-1B who then later travel outside the US and undergo consular visa stamping after they've been approved stateside. Also exempt are those who have applied for and attained a national interest exception to being subject to that fee. We've outlined on that slide what the requirements are. And notably, we have not heard yet of anyone actually being granted this exception. So it's a very high threshold to meet of extraordinary, rare circumstance. And we're still tracking closely to see if any of these have been reviewed and approved. And to date, we're not aware of that. So certainly don't count on that happening. Now, as far as paying that fee, we do have a number of clients who are still willing to go forward with the H-1B lottery, knowing that the intended beneficiary will be subject to that fee, and they're willing to pay that fee to get the talent that they're looking for. So as far as paying that fee, how is it collected? There is a government website, pay.gov, that you have to make the payment on and have evidence of having submitted that payment. That must be included, that proof must be included with the petition submission. Or if at some point you have an individual who has been approved for that NIE exception, then evidence of that approval has to be submitted at the time of filing. I do want to point out that the $100,000 fee itself and that proclamation is subject to several ongoing lawsuits. There are multiple legal challenges seeking to invalidate that fee and block the policy's implementation. So things are very fluid in this space, and there are hearings scheduled for later this month and next month as well on several of those lawsuits. So as of right now, today, that fee is still very much in place, but things could change. So remain in close contact with your immigration counsel. So now that we've covered the H-1B lottery program and related changes, we want to look ahead beyond the lottery and touch upon some general tips for your visa holder workforce. So I'll turn it over to Molly for that.
Thanks, Fatma. I know we're a little over time, so I'll try to go through these relatively quickly, but just some quick reminders for your foreign national workers. You do want to encourage them to keep proof of their status with them at all times. As I'm sure you guys have seen in the news, people can be stopped just on their way to work or on, public transport, whatever it is, and be asked for proof. So it's important that they carry that with them, whether it be a green card, copy of their green card, their actual green card, their passport, or approval notice, or most recent I-94, whatever it may be. It's also a good reminder for employees to always check their I-94 after traveling abroad and returning to the U.S. We often see situations where CBP makes mistakes on the I-94, and so it's easier to fix it if you catch that right away, other than trying to fix it down the line when you're getting ready to file an extension application or a petition of some sort. Another good reminder for your employees is, especially those who are working on employment authorization documents, is to encourage them to file for renewals early. They can file up to 6 months before the expiration. And this wasn't quite as important before because there was an automatic extension of their authorization to work when an extension application was filed. But as Martha mentioned, that was eliminated last fall. So they really do need to file early to avoid any gaps in work authorization. Additionally, as discussed, DHS is looking into people's social media activity and requiring individuals who are seeking certain statuses to make their social media profiles public. So it's good for employees to be aware of that and conscious of what they're posting on social media. And they also want to be thinking about what is on their online profiles and then making sure that it matches the details and information submitted to the government in visa applications and petitions. So checking LinkedIn and make sure the employment history and the titles and all of that match what is being represented and what's filed with the government is important. Finally, and this is an easy one to forget, and I know doesn't always happen, but it's required, so it's important. Foreign nationals are required to notify USCIS of any change in their address within 10 days of moving, and they do that by filing the AR-11. This needs to be done in a timely manner because it is required, and it's also important to avoid missing any important mailings or notices from the Department of Homeland Security, because they're going to use the address on file that you've last reported. And even if somebody has their mail forwarded through the U.S. Postal Services, DHS mail does not always get forwarded through that, and so they might miss things. So it's really important and an important thing to stress for your employees. So that's all I've got for that. I think I'm gonna hand it back to Martha to go over the resources.
We have covered a lot of information today. So as we close, we just want to leave you with a few reliable sources for the H-1B lottery registration and recent immigration law changes to help you stay informed and compliance in this constantly evolving area of immigration law. Now I turn it over to Fatima to conclude our presentation.
Thank you, Martha. Thank you, Molly. And thank you everyone for joining and participating in our webinar today. Please be sure to complete and submit the survey that will display at the conclusion of the webinar. Have a great day.